Mr. Stone is before the court. He was 14 years old when this event happened. He had absolutely no prior criminal history on his score sheet whatsoever. He's never even been on probation with the Department of Juvenile Justice, obviously never been committed to a juvenile program. His brain was nowhere near fully developed when this incident happened and is still probably 10 years off from that being.
Pause right here. This is a defense laying foundation for mitigation. Age, no criminal history, and an underdeveloped brain aren't excuses legally, but they are powerful factors courts consider when deciding punishment versus rehabilitation. The question is, how much weight should they really carry when the crime itself is severe?
The case. He had a relatively difficult childhood. He had no father figure in his life whatsoever, and certainly none of this is an excuse or a justification by any means for what happened. He is remorseful about what happened. You've heard testimony about that. He pled guilty, but he, lost contact with his sister, I believe, shortly before this happened. He very minimal contact with his mother, and he was essentially raised by his paternal grandmother. Despite all that, he's done fairly well in school. He got ahead of grade, made pretty good grades, A's and B's, I believe it was. We believe that indicates that he would be amenable to supervision as well as specialized sex offender treatment.
This is a critical moment. The defense acknowledges mental health issues while carefully saying, this doesn't excuse the crime. That's strategic, because juries and judges shut down fast if they feel psychology is being used as a shield instead of context. Do you think mental health should reduce punishment or just shape treatment?
As the state points out, he does suffer from depression and ADHD. And obviously there are plenty of people that have depression and ADHD that never get involved in anything like this, but that combined with his childhood certainly doesn't help. As a 14-year-old boy with, again, no father figure in his life, he appears to be somewhat get addicted to pornography and things of that nature on the internet. I'm sure that didn't help this situation. Dr. Williamson does indicate that he would benefit from specialized psychiatric, psychological, and sex offender treatment. The Department of Juvenile Justice is well equipped to handle that with a 14-year-old child. The Department of Corrections, it's our position, would not be. They're accustomed to dealing with adults. And
here's the core argument. Prison versus rehabilitation. Juvenile justice focuses on treatment and growth, while adult prison is about punishment and containment. Once a child enters the adult system, the odds of rehabilitation drop dramatically. The court now has to decide, protect society now or invest in preventing future harm.
Even teenagers that are older, in the neighborhood of 17 or 18 years old, Mr. Stone would be in a better environment if he were around kids his age and not institutionalized with people in prison, other adult sex offenders in prison, and things of that nature. None of that is going to benefit him in growing up and growing out of this and being rehabilitated. Certainly there has to be some punishment involved, and we acknowledge that, but there does need to be, we believe, some element of rehabilitation that he's not going to get in the state prison system as a 14-year-old sex offender. Your Honor has probably the widest range of sentencing options that I've ever seen before.
That comparison hits hard. 135 months is almost the same number of months he'd been alive. This is where sentencing stops being abstract and becomes deeply human. Is proportional punishment about the crime alone, or should the defendant's age and life experience matter just as much?
You could sentence him to juvenile sanctions. You could put him in a high-risk program and retain jurisdiction through his 21st birthday. That's what we would ask the court to do. If the court does not believe that's appropriate, Mr. Stone would qualify as a youthful offender based on these charges. If the court is inclined to send him to prison, we would ask that.
This is a turning point. The judge rejects juvenile and youthful offender options outright, calling the actions egregious. When a judge uses language like that, it's a signal. The scale has tipped fully toward punishment, and the victim's survival becomes a dominant factor in sentencing.
It'd be as a youthful offender with a portion in prison, followed by a portion on sex offender probation so that he can get the treatment that he needs in an outpatient type setting. He scores, I believe, around 135 months. If the court is not inclined to give him juvenile sanctions or youthful offender sentence, we believe that that would be a rather substantial punishment, almost as many months as he was alive at the time of this incident, to be followed by probation. Your Honor, sentencing him to 30 years or 40 years or 50 years in prison for his first ever arrest. We agree that there does need to be some punishment here, but he's 14 years old and has never been arrested before, so we just ask the court to have mercy on him.
All right, thank you. I do not think juvenile sanctions or youthful offender sanctions are appropriate under these circumstances. His actions are egregious, and the victim in this case is lucky to be alive under these circumstances. State, did you want? I am going to sentence him to prison, followed by a lengthy term of sex offender probation. I don't know if you want to be heard as far as conditions now or after I impose the DOC sentence.
I believe the standard sex offender conditions would be sufficient. That would include treatment and as well as no contact or internet use without the risk assessment. So I believe that would encompass everything that's needed.
Okay. So once I announce my sentence, if there's something additional either side thinks that I should address, I'll be glad to do that. All right, Mr. Stone, this is unfortunate for you, for the victim, for both of your families. I'm going to start with count 2. It's a burglary of a dwelling with a battery, which is punishable by up to life in prison. You're adjudicated guilty and sentenced to 25 years in the Department of Corrections. That's going to be followed by 30 years of sex offender probation. You're going to have to follow the sex offender probation conditions set forth in 948.30, which includes sex offender treatment, a variety of other things, including polygraphs.
Let this sink in. 25 years in prison, followed by decades of sex offender probation, strict monitoring, and lifelong registration, all imposed for actions committed at 14 years old. Whether you agree or not, this sentence effectively defines the rest of his life. Does the justice system believe people can truly change after crimes like this?
No use of the internet without a risk assessment, no contact with children under the age of 18. I don't know that that's going to be applicable in this case, but I assume all those are still going to apply. You cannot have any contact with the victim in this case, which means that no phone contact, third-party contact, no contact in any manner whatsoever, no electronic contact, no writing. You can't go within 500 feet of where she's living, and you can't go within 100 feet of a vehicle that she's in, and that will be during the entirety of your DOC sentence and the probation. You're going to have to register. It is a sex offender, right? Not sex predator?
I believe it's sex offender due to the nature of count 1.
Okay. You are going to have to register as a sex offender pursuant to 943.0435. Let me address count 1 now before I continue, because the conditions are going to be the same. On count 1, which is a sexual battery, you are adjudicated guilty. You're sentenced to a term of consecutive probation to the prison sentence on count 2. So it's 25 years in the Department of Corrections, followed by 30 years of sex offender probation. The probation on count 1 is for 15 years of sex offender probation, concurrent with the 30-year sex offender probation sentence on count 2, which includes all the conditions of sex offender probation outlined in 948.30, including the no contact provision that I just announced, will be applicable to both counts. Additionally, you do have to register as a sexual offender pursuant to 943.0435 for both counts. Additionally, you must complete a mental health evaluation. You must make arrangements to have the mental health evaluation within 60 days of your release from the Department of Corrections. Thereafter, you must comply with any recommended treatment or counseling. You must also enroll in an anger management course within 60 days of your release from the Department of Corrections, and you must successfully complete it on the first attempt. Once again, you're not to have any contact with the victim. It relates to both counts. On each, actually on count 2, you're going to receive credit time served in the amount of 237 days. There's a $500 fine plus mandatory court cost, $100 cost of prosecution, $100 cost of defense, $50 public defender application fee, and you must provide a DNA sample for the FDLE database. As I said, the DOC sentence of 25 years is followed by consecutive sex offender probation on count 1 and count 2. So, what do I need to address as far as conditions of probation from the state's perspective?
I would request that the court add that the defendant must comply with all registration requirements as a sexual offender as a condition of the probation.
Okay. And I announced the statute, but you must comply with all sex offender reporting requirements pursuant to statute. And that will be applicable to count 1, the 15 years, and count 2, the 30 years following the DOC. Mr. Mills, what else do I need to address related to any conditions of probation or the conditions of the sentence?
Nothing further from the defense, Your Honor.
Okay. You do have 30 days to appeal. All right, is there anything else that needs to be addressed?
No, Your Honor.
Mr. Mills, did you want the evaluation of Dr. Williamson in the court file?
Yes, please, Your Honor.
Because I wasn't sure if it had been filed yet.
Right, thank you. That
All
would
right.
be perfect.
And for the record, I provided the court the score sheet in advance.
Yes, and I have the score sheet here, and I know Mr. Mills referenced the lowest permissible, which was reflected in the score sheet that I had. You're more than welcome to review it, Mr. Mills, if you want to.
No, thank you, Your Honor.
See it?
We didn't have an objection to it.
Okay. Okay.
Thank you, Your Honor. May I be excused?
Yes, ma'am.